Welcome to this second season of Altea Talks, the dedicated podcast being brought to you by Altea, the unique provider of combined insurance and risk management solutions designed exclusively for the medical, allied health and care sectors. I'm your host, Will Marshall, and I'll again be joined in this second series by some of the leading figures from across the sectors. My guests are going to include practitioners and professionals, regulators, clinical risk and governance specialists, and an array of legal experts who are going to help us get to the heart of the hottest topics affecting health and social care sectors today. So, if you're looking for frontline knowledge and expertise, if you want valued insights into these most dynamic, challenging, and rewarding of sectors, then look no further because you're in the right place. Welcome again to Altea Talks. Hello and welcome to this latest episode of Altea Talks. This week I'm delighted to be joined by Charlotte Ellis. Charlotte is an experienced healthcare regulatory lawyer based at DWF in their Manchester office. Charlotte acts for indemnifiers and indemnified and non-indemnified healthcare professionals and organisations throughout the sector. Charlotte has practiced in the healthcare sector for over 20 years and specialises in the defence of practitioners and organisations. She acts in the defence of professionals and organisations facing inquests, fitness to practice investigations, criminal investigations, trust disciplinary investigations and hearings, and deanery procedures. Charlotte predominantly acts on behalf of insurers and indemnity organisations, and she also undertakes inquest work for Altea in relation to some of our care home clients. She works for GP practices on behalf of the MPS and for NHS trusts, where she's instructed by NHS resolution. Charlotte has defended individuals from the start of fitness to practice investigations right the way through to appeals in the High Court. And she notably acted for the defendant doctor in the leading case of Cohen, which changed the way in which procedurally the GMC MPTS assess fitness to practice issues. Charlotte is an advocate at inquests, trust disciplinary hearings and interim orders tribunal hearings. She's very kindly agreed to join us today to talk specifically about inquests. Charlotte, a very warm welcome to Altea Talks.
Oh, thank you, Will, and thank you for having me.
It's an absolute pleasure. As I said, we're here today to focus on inquests, which I appreciate is one aspect of your work, only one aspect. But I think it would be helpful for the benefit of our listeners if we could take it back to the beginning. And we're talking about healthcare related inquests. And I just wanted to ask you this to kick us off. When there's been a death in a clinical or care setting, a decision presumably has to be taken about whether the case needs to be referred to the coroner at all. And the coroner would then need to consider whether he or she has a duty to hold an inquest. Could you please walk us through what's involved in that process, and particularly what the factors are in your experience that would make it more or less likely that the coroner is going to order there to be an inquest where there is an element of discretion about that decision?
Yeah, sure. I'll certainly try. So you're right. There is an element of discretion as to whether or not a case needs to be referred to the coroner. Any such referrals are normally made by doctors or the police. But as with most things in the law, there's a long list of circumstances in which a death should be referred to the coroner. It might be useful if I just give some examples. So it's deaths where that could have been due to violence, trauma, injury, self-harm, self-neglect, or the death was due to a person undergoing any treatment or procedure of a medical or similar nature, the use of a medicinal product, so prescription medication, the use of a controlled drug or psychoactive substance. And I mention those examples purely because those are examples that we see in legal cases that I have I've dealt with recently. There are more on the list, but those are the ones that I've identified as being pretty good examples of when you could see somebody referring the case to a coroner.
Yeah, sure. Thank you. And there are certain categories of case, aren't there, where the coroner has to call an inquest?
Yeah, that's absolutely right. So take it back just one step. So if a death is reported to the coroner, then the coroner's got to decide either that the cause of death is clear, that a post-mortem is needed if it's not clear, and then whether or not to hold an inquest. So if the coroner decides that the cause of death is clear, they simply issue the certificate to the registrar saying that a post-mortem or inquest isn't needed, and that's the end of the matter. And then the registrar registers the person's death. But if the coroner decides the cause of death isn't clear, then he or she can decide that a post-mortem is needed to find out how the person died. Can be done in hospitals, mortuaries, and sometimes they can even be done by CT scan. Actually, on that, I wanted to have a bit of fun. I actually did some work experience with the coroner in Sheffield, and Sheffield's one of the few locations in the country that has a CT post-mortem scanner. So in my work experience, I was able to go down and actually see postmortems being done with the scanner. And nowadays, for religious reasons, the coroners very often don't want to do invasive postmortems unless they have to. So the CT scanning is being done more and more. We just don't have the facilities across the country. So yes, seeing the bodies in the postmortem scanner was interesting, and how they interpret those scans, I do not know, to determine a death. Obviously, sometimes that CT scans are not going to be enough, and then they still have to do an invasive postmortem. But I thought I'd share that little story with you. Nobody, including the family, can object if the coroner decides that a post-mortem is necessary. But if asked, the coroner then must confirm with the person who's asking and the deceased GP when and where the examination is going to take place. So I know we're digressing a little bit onto post-mortems, but that is an option for the coroner to do a post-mortem when the cause of death is unknown. But in terms of your last question, Will, where a coroner has a duty to hold an inquest, the coroner has to hold an inquest, must hold an inquest if the cause of death remains unknown. The person may have died a violent or an unnatural death, or the person might have died in prison or in police custody. So it's basically the opening of an inquest that has to happen if there's a reasonable cause to suspect that the death was due to anything other than natural causes. Natural causes being defined as disease process that runs its natural course where nothing else is implicated, or where the death occurred in state detention. And those are the generally longer inquests that run with a jury, because Article 2 is invoked, which we won't go into because that is a topic in itself.
Thank you. Yes. And I think just for the benefit of the audience, really, there's quite a lot of mystery surrounding what an inquest actually involves. By that, I mean what the coroner is trying to establish. Can you explain a little bit about that, and also explain how inquests differ from other types of legal proceedings when it comes to examining the role of medical treatment and care involved in a clinical death?
Yeah, absolutely. And I think you're right. I think there is a lot of confusion, misconception, worry, particularly for those who are called to give evidence at an inquest about inquests and what they actually are designed to do. I always think it's a fun story, and I'm a bit of a history buff myself. But the role of the coroner has actually adapted over 8 centuries since the office was formally established in 1194. So it was a form of medieval tax gatherer to an independent judicial officer charged with the investigation of sudden, violent or unnatural deaths. The original duties of coroners included the investigation of almost any aspect of medieval life that had the potential benefit of revenue for the crown. So it was basically a money-making role.
Death and taxes, eh?
Absolutely, death and taxes. But in 1836, the First Births and Deaths Registration Act was passed, prompted by the public concern and panic, which was caused by inaccurate recording of death numbers for diseases such as cholera. And then in 1846, we have Sergeant William Payne, Esquire, who wrote to coroners to form the Coroners Society of England and Wales. And so began the regime we see today, which I always think is a nice story for anybody who is worried about attending an inquest. It's one of the oldest court, well, probably the oldest court in the land, and the coronial role is one of the oldest legal roles in the land. So just think of that if you ever have to give evidence, nothing to worry about. But what is it? What is it nowadays? It's a public fact-finding inquiry only, and the coroner is only charged with establishing the answers to 4 questions. And they are who the deceased was, when the deceased died, where the deceased died, and how the deceased came about their death. So I always explain that how in this context means by what means. In the simple English language, by what means did the person come by their death? I've alluded to Article 2 inquest previously, just now, which we won't go into, but that does widen the scope to by what means and in what circumstances. So interpretation of how is just the normal English interpretation. The coroner uses the inquest to confirm the particulars required to allow the death to be registered, to ascertain the medical cause of death, and to record a conclusion, which listeners might have heard of before as a coroner's verdict. It's just previous terminology that changed with the Coroners and Justice Act 2009. So they are, or they should be, very different to other types of legal proceedings when it comes to examination of the clinical care provided to the deceased, because it's absolutely not supposed to be a blame-finding process at all. So inquests can't deal with issues of blame or criminal liability or civil liability, and should absolutely be non-adversarial, which should reassure any listeners who might be thinking, oh gosh, if I ever get called to an inquest, they should not be adversarial. I very often hear coroners inform parties at inquests, and it's normally the families, to be fair, grieving families, upset families who might not be represented, asking questions that are adversarial because they're angry at the upset and loss of their loved one. So very often I'll hear coroners inform the family members or other parties that these sorts of issues should not be addressed at an inquest. They should be addressed in other courts if necessary. But I think it's important to give a word of warning in relation to this topic, because any evidence that is given at an inquest can potentially impact the decision as to whether somebody, usually the family, wishes to bring a claim. And then if a claim is brought, any evidence given at the inquest can be scrutinised and potentially picked apart during the civil proceedings that are subsequently brought. So a word of warning, but they are very different to other courts in England and Wales.
Thank you. And just whilst we're on that topic, certainly anecdotally, I have heard recently from a lot of stakeholders in the health and care sectors that inquests are becoming more complex, more challenging, and more important. And I really wanted to ask you a question about that, which is why, in your view, have inquests, it seems to me relatively recently, become so important to, well, firstly to providers of health and care, but also to their insurers as well?
Yeah, I think you're right. I think since COVID-19, we've seen an exponential rise, or we thought we were seeing an exponential rise in the number of inquest instructions received. Inquests probably make up around about 85% of my workload now, which they never used to. Initially, we thought it was because of COVID-19. There was obviously a backlog of cases because inquests couldn't be held during the pandemic. But that doesn't appear to be the case, because the cases continue to come through at the same rate after COVID. I think there is and perhaps this is something we'll come to later, because I realise this isn't really the answer to the question, but there is an emphasis on duty of candour, open and transparent proceedings. I think people are more knowledgeable, families are more knowledgeable. They now know that they can put pressure on a coroner to bring an inquest if they wanted to. I think people are, as I say, more informed, that they know their rights. But it's now almost inevitable that healthcare professionals will be called to an inquest at some point in their professional lives. Now, I don't say, lots and lots of inquests, but certainly one or two. Most clients that we represent at the moment have been to an inquest before, even if they've not given evidence. They've been to support somebody or whatever. So it's becoming a much more common thing. I think for providers, obviously inquests are important because damage can be caused to the provider's reputation during an inquest. And also the fact that evidence given at an inquest can impact whether a civil claim is brought against the organisation. So they're quite important in that respect also. Providers have staff members. Obviously, staff members may be called to give evidence. The providers should be providing support for those members of staff who are attending an inquest because they may be nervous, anxious. And as an employer, we owe duties of care to our staff. This will mean time away from work for the staff member. It means time away from work for management who are supporting, which obviously has an impact and its own cost implications. And that in turn could have an impact on patient or service user care because the members of staff are not available on the days. Now, it sounds ridiculous because it sounds like an inquest, so it's just, potentially the listeners are thinking, oh, it's only a day. But that's not necessarily true. They can have significant cost implications. They can be listed for a day, they can be listed for 5 days, weeks, depending on the nature of the circumstances. Whether or not the inquest is an Article 2 inquest, which we've alluded to, whether a jury is required, how complex they are. Having said that, most inquests don't require a jury, but I won't go into that today. But suffice to say that they're not always finalised quickly. So can mean significant amounts of time off work for staff who work for the providers. Insurers.
So there's an internal cost element for providers as well.
Yeah, there is. And the risk of an external cost, obviously, that we've talked about. Lawyers, like me, get instructed to represent the insured as well. Obviously, significant costs potentially there, depending on preparation time, the length of the inquest, etc. And sometimes counsel in really, really complex inquests. It may be more cost effective to have counsel and may give the correct impression to the coroner if everybody else is represented by counsel, depending on the circumstances of the case.
And we're talking about public hearings and often quite newsworthy content. So they generate a lot of publicity, or they can generate a lot of publicity.
Yeah, they can. Anybody can attend an inquest. They're public. People attend to listen out of interest, press members, even if they're remote. If members of the press get wind of the fact that an inquest is remote, which has happened more and more since COVID. Some coroners allow it all the time. I find that coroners in the south of England are much more likely to allow it, weirdly, than in the north. I don't know why that is, but press join the gallery, if you like, on a Teams link.
Well, can I just ask you about that, about remote hearings, and as an advocate, what sort of challenges does that pose for you? What's your preference? Do you prefer to appear in person or remotely?
I prefer to appear remotely, only because you're in the comfort of your own home, so you're much more relaxed and calm in any event, because inquests are tricky situations for everybody, including the advocates, can be. But mostly generally because I don't act necessarily for families. I have acted for one family member because inquest procedure is the same, whether you're acting for a healthcare provider or a family member. But generally my work is to act for providers or healthcare professionals. And it takes the heat out of it, in my view, because both you and your client, I would never send a client to an inquest and I would attend remotely. It's either we're both attending remotely or we're both there in person. But it takes heat out. Families can be, as I've alluded to, really quite angry. You don't know exactly what they're going to do. You don't know how you're going to be received as the advocate for the doctor who has apparently killed their loved one, or anything like that. I have been spat on outside, or tried to be spat on outside of court by family members long time ago. You just don't know what's going to happen. Most families are absolutely lovely, but I can understand that grief can cause them to do things they may not ordinarily do. So I think it takes the heat out of it. Having said that, a really good example of where it goes wrong is what happens if your computer crashes in the middle of an inquest. There is absolutely nothing you can do but try to get back on with another device. And I always think that's only ever happened to me once, but I just thought, well, there's nothing I can do on this computer, that I'm just going to have to get back on. And the coroner, I think, not just the coroner, any organisation that allows remote hearings is well versed in technological difficulty. So I think that there's a lot of understanding there. So yeah, it's stressful when it happens and you drop off the link or your computer crashes or whatever, and that's always going to be a risk. But personally, I think that remote inquests are absolutely brilliant for taking the heat out of the situation for both the client and to some extent for you as an advocate.
Yeah, thank you. And can I just ask you a little bit about the status of people attending or called to attend an inquest? Because my understanding is that you can attend in different capacities. You might be called as a healthcare professional to attend as a witness, but if you're a provider, you're an entity, you're a hospital or a clinic or something, then you can acquire properly interested party status. And could you just talk me through that and what the the implications of that distinction are in practice.
Yeah, okay. So when I first started doing inquests 15 years ago, they were called interested parties. So now the legislation, the Coroners and Justice Act 2009, has changed that because I think it was felt that parties made it sound adversarial. So they've changed that, and there are now no parties to an inquest. And I think it's because the duty to investigate falls to the coroner. So the terminology's changed, and it's now properly interested persons.
My bad.
So that can be providers, organisations, or it can be individuals. So persons is a little bit misleading because it can apply to organisations. But they are those who have a proper interest in the proceedings. That's the definition. So are given rights to participate in the investigation and the inquest. We call them IPs for short. There are, however, other people who are called to give evidence who are not IPs, and they give evidence as witnesses of fact. So the difference being that witnesses of fact are not provided with a copy of the documents or the inquest bundle. So they are literally giving evidence in the dark with no knowledge of what anybody else has said, and they're not entitled to legal representation either. But those automatically entitled to IP status without having to apply for it would be entitled to legal representation, would be entitled to the bundle, and they would be the deceased family would automatically be entitled, and other individuals that may be related to the family, such as personal representatives, for example. And those whose actions those whose actions contributed to the death under Section 47(2)(f) of the Coroners and Justice Act. It's almost presumed that that person has contributed to the death just by the wording of the legislation. But good examples of interested persons are maybe a care home, nursing home, where a resident has died at the care home as a result of a fall that nobody witnessed, or a GP who last saw the deceased before death. So many GPs, as we know, can see us as patients, but it's normally the one who last saw the patient before they died that is then called as an interested person at the inquest. But then there's a catch-all provision also. Don't you just love the law? And it says that interested persons can be any other person with sufficient interest. So literally anybody. And that's Section 47(2)(m) of the same Act. So it kind of affords the coroner a really wide discretion because it's then down to the coroner to determine who he or she thinks has this sufficient interest. And helpfully, the term isn't defined either. So sufficient and interest are just held to be ordinary words that should be given their ordinary English language meaning, with each application determined on its facts. So I've made the distinction there and not really explained what I mean about automatically entitled. We've talked about those who are, and also those who apply for interested person status. Witnesses might want to do that. You would need to ask the coroner to grant you IP status, but sometimes tactically it might not be a good idea to do so, because you might want to keep that low profile. If the coroner doesn't think that you're sufficiently interested to be an interested person, then but wants you to come as a witness of fact, then you might just want to keep that low profile and not stick your head above the parapet, if you like. Because I think then you can almost assume that the coroner isn't looking to be too critical of the care provided by that particular person. But the flip side is that interested persons have the right to see the bundle, and that can be really helpful when a witness is preparing for an inquest and giving evidence, and also is then entitled to legal representation, so gets some protection at the inquest.
So just on the point of the bundle, if you are reporting to the coroner, what documents do you have to send to the coroner? And presumably from what you've been saying so far, any documents that you do share with the coroner are going to be disclosable to other interested persons at the inquest, including the family and the family's representatives, if they have them.
Yeah, potentially. So normally what will happen is that the coroner will ask the individual for a statement, or the organisation to provide a statement. And this is the strange thing about inquests. You don't really get to see the correspondence going on behind the scenes with the other interested persons, not very often. So they will ask the organisation or the individual to, if they've identified an individual, say, let's just, for argument's sake, choose a GP surgery. And they've identified that the last GP that saw this person was Dr. Smith. The coroner will then write to the practice and say, we want a statement from Dr. Smith. And so Dr. Smith then prepares the statement. And the doctor will then make reference potentially to the GP records. It's incredible, though, in the example I've just given, how many coroners don't actually include the GP records in the bundle. This is a case that involves a GP or a GP practice. Don't include it in the bundle. It's really strange. But the doctor will go through the clinical records, not necessarily appending the records to the statement, but certainly should append potentially any policies that were in force at the time of the death, the policies within the organisation, any reviews conducted, such as significant event analysis or serious incident reports, etc., that have been done. Anything apart from the clinical records, really, that the coroner might be interested in if it relates to the death. So those are the documents that you'd be looking to try to obtain before the inquest and to enclose with a witness statement.
Thank you. And just moving on to witness statements, because I know that there'll be a lot of interest in this, but when a clinician or a care professional is contacted by the coroner or contacts the coroner, when might they be asked to provide a witness statement for an inquest? What would typically their role with the deceased person have been that would make them a potential witness of fact that the coroner would want to hear from?
I think that clinicians or care professionals are usually asked to provide a statement to assist, bearing in mind, and this should be borne in mind, to assist the coroner. So that's why they would be asked. But to assist the coroner in determining who should be an interested person, for example, at the beginning, because the coroner doesn't know who exactly is going to be an interested person. So I think the statements help the coroners to determine that, who should be a witness of fact, and we've discussed the distinction between the two. And actually, which witnesses might not need to give evidence at all at an inquest. That's the first thing that I always think, well, they're asking for statements here because they need to see who's most involved. Usually the witnesses that are called to give evidence at an inquest are those who have been directly involved in the deceased's care, closest in time to the death. They will be the most relevant. And this, as I've said, normally results in the witness reviewing the clinical records then and documenting the facts of what's recorded in a witness statement.
Why is it so crucial to get the statement right? And I guess the flip side of that is, what are some of the most common mistakes that you see that healthcare and care professionals make when writing these statements?
It's a good question, a good couple of questions, because witness statements are so important and therefore it is so important to get them right. It forms the basis, after all, of the evidence the witnesses are going to give at the inquest. The coroner, the process is that the coroner will take that witness through their statement and ask the significant majority of the questions based on it. So a well-drafted and a well-prepared statement can, A, avoid frustrating the coroner, which nobody wants to do, and can set out the picture more fully, providing an aid memoir to that witness. It can sometimes, as we've said, avoid that person or an organisation being made an interested person and having to attend to give evidence if the coroner thinks, well, actually, I've asked for a statement, but actually I don't think that person's particularly involved. It avoids the coroner questioning the reliability and credibility of a witness who prepares a badly drafted statement, for example, and then gives evidence and provides much more detail or even conflicting detail, not because they're dishonest, just because they haven't done a decent statement at the beginning. Nobody ever wants to hear the question, why does that not appear in your witness statement, Dr. Smith? Certainly the legal representatives don't want to hear that. And so it's just so important for giving the right impression and to help the coroner and the witness to do a proper, thorough, honest statement. And I'm sure we'll come to PFD because I'm anticipating that you will ask me about PFD, which is prevention of future deaths. But
it's coming, Charlotte. It's coming. But just whilst we're on statements, I've seen, and I'm sure you have on numerous occasions, statements that sort of vary in formality, and you don't get the same sort of prescribed format of witness statements in inquests that you would see, say, in civil litigation under the civil procedure rules and so on. What do you say about that? I mean, is it really important for the statement to be well structured, and do details like, I don't know, numbered paragraphs and a clear chronology really matter? And my final question on the format is, What about a statement of truth? Would you expect a statement to be supported by a statement of truth?
I think in answer to that stream of questions, and I understand why they're lumped together, I think we should, and I know you've asked me about this previously, about common mistakes in a statement, so that's probably the starting point. Not explaining the basis for a decision that's been made is a common mistake. So not explaining how the witness reached the decision or diagnosis based on the facts of the case, just ignoring it, that's a mistake. A really important mistake is including personal opinion in the statement. So, for example, in my view, nurse A, Dr. B is at fault for not doing X, Y, or Z. In my view, says nurse A, Dr. B is at fault. In her statement, she says this. Not making necessary concessions in relation to the person who's making the statement's practice. So not sort of accepting where things might have gone wrong. Not highlighting areas of reflection, learning, or changes in practice as a result of the deceased death. And not being mindful of the tone, I think, is really important. The tone of the statement, the tone that's used. And a major mistake that's made and is so easily remedied is that witnesses don't review the content carefully before they sign the statement to ensure that the content of the statement is accurate. So those are common mistakes that are made. But in terms of importance of structure, I think it's really important, both for presentational purposes, the impression it gives to the coroner, etc., and even to the family. So a well-structured statement, if you want my hints and tips, would be that the person should introduce themselves in terms of name, job title, qualifications and role, to give the coroner a bit of a flavour of that person's experience. Numbered paragraphs, really important, and we'll come to why. I'll explain that in a moment. Should not be written in the form of a letter because it's just too informal and can't really be followed when the person's giving evidence. And again, that ties in with the numbered paragraphs point. Should set out in chronological order from the first occurrence to the last, what's happened. Should provide sufficient explanation of other people's names and job titles, because remember, the coroner doesn't know who any of them are. Should set out the titles of any policy documents referred to. And really important, should set out any clinical terminology, because coroners used to be able to be doctors or lawyers used to be able to be coroners. Now it's only lawyers. So the doctors who have previously been coroners are being phased out as they retire. So the chances are that the coroner hearing the case may not actually know what is meant by certain terms. So just define it if you possibly can. A decent statement should enclose documents that are referred to within that statement and should end with a statement of truth. So I just wanted to pick up on a couple of those that you'd asked about the numbered paragraphs. I think details like numbered paragraphs are of significant practical importance during an inquest because the witness is going to be giving evidence. It makes it easier for the witness, i.e. our clients, to refer to the relevant sections of the statement when they're discussing certain areas of the care provided, and it also makes it much easier for the coroner when the coroner's asking the witness questions. You know, Dr. Smith, can you turn to paragraph 4? In paragraph 4, you say X, Y, Z, just so much easier. But it also gives the overall impression of a credible, well-organised witness who can be relied upon. I think I said that the statement of truth was also something that I thought was really important. I absolutely do think it's important, which obviously you wouldn't get if you drafted it informally in a letter format, for example. I think it's important because it's somebody who is signing a statement of truth, stating that they have an honest belief in the truth of the facts that they've stated. And if it's not the case, then that person signing could be held to be in contempt of court. So some pretty serious consequences that could result in a prosecution, a fine, a custodial sentence. So it's not a matter to take lightly. And the coroner will know that. I think statements of truth add to the integrity and credibility of a witness, but absolutely should not be signed if the witness is in any doubt about the accuracy of what's potentially been drafted for them, or if it's not what the witness truly feels is a true and accurate reflection of events, because as I've said, it can have consequences. So I just think it gives the right impression of a decent, credible, honest witness. So I really do think that it's very important.
Yeah, thank you. Can I just ask, in cases where you've got several professionals from the same organisation involved in the deceased patient's treatment, how do you go about coordinating their statements to ensure they're consistent and also to avoid any suggestion of collusion? My other related question on that is, what happens if one witness is at odds with the others. Their recollection is different. They have a different explanation for what happened. How do you manage that scenario?
It's tricky. I think to take the first question, I think it starts with preparation. So the best way to approach the sort of situation where there's several professionals involved, you don't want to have any collusion, you want to ensure consistency, avoid duplication, etc., is to make sure that each person, and again, I think this is an organisational duty, not a duty, but an organisational role to ensure that their employees know the purpose of an inquest and what's expected of them when they're preparing their statements, so that there's no surprises. Witnesses are not allowed to collude when they're providing their evidence, whether that be in written format or when giving live evidence. So, for example, if you're at an inquest and it's lunchtime, then you will very often hear the coroner say, you're still under oath, you can't speak to anybody about your evidence. So it's still just as important as it ever was. So I think that the drafting of a witness statement should be done independently. Each person should give their statement, either draft their statement independently or have it taken to be drafted by somebody else independently of the other witnesses, and that assistance that might be needed given to them independently. But the witnesses shouldn't work blind. The documents relevant to each witness should be provided to them, and they should then each be asked separately to have a look at the documents and to provide a draft outlining in chronological order the facts of the case and their individual involvement. So drafts can be completed and then assistance given to tidy things up. And sometimes a statement is drafted by the legal team with the individual, who then reviews and amends. But absolutely crucial that that person reviews and amends their own statement to ensure that they're happy that it's factually accurate. In terms of duplication, I wouldn't be too concerned about duplication, because in some ways it shows consistency between the witnesses. But in any event, the coroner is going to determine what questions are asked. It shows that you haven't colluded if there is duplication, but the coroner is going to literally take these witnesses through their statement, and if the question's been answered to the coroner's satisfaction, he won't ask that same question of the next witness necessarily. It's strange because very often we have in every case we have pre-inquest meetings, and that involves all of the witnesses. So those witnesses all come to one pre-inquest meeting with me, and we talk about the case, we talk about inquest procedure, etc. We explain what is to be expected, but that happens after the statements have been drafted and disclosed. So there's absolutely nothing wrong with that at all. That can lead to helpful discussion in the round in preparation for the inquest. So jump in now to the second part of your question. How do you handle it if you've got two witnesses giving conflicting accounts? That happens quite frequently, and I think the trick is to work out whether there is actually a clear conflict. If you've got one witness saying, well, that happened, and the other person saying, well, absolutely no, it didn't. It really depends on whether there's any middle ground, whether there's any vulnerabilities for either one of those witnesses. So if there is, then that can create a conflict situation, which means that one of them will need to be released from the hypothetical umbrella of the organisation, and they can go and get their own representation at the inquest as an interested person. So it does happen. It happens in hospitals with locum doctors quite often. I've had a few cases where there's been a locum who is trying to work in an organisation perhaps that they're not used to. And of course, they're not a permanent member of staff. And so witnesses are giving evidence from the trust, but then it's the locum that has to then go off and get their own separate legal representation, because the trust is not protecting necessarily the locum, rather protecting their own staff, and there is a conflict between them. So it can be dealt with, and it doesn't always mean they have to go and get their own separate legal representation. If a witness might say something slightly different to another witness, and it may not cause a conflict. So it's an assessment on a case-by-case basis.
Yeah, thank you. I think to move it forward to the day itself, to what actually happens when you get into the courtroom as a witness or as an interested person. And for health and care professionals, I know you've said most of the professionals you work with have previously been to an inquest, even if they haven't given evidence. But what should they expect from the process, and what kind of preparation can you provide as a legal representative to help make the experience less daunting for them?
Yeah, I think the first thing to remember is that anybody giving evidence in any court across the country is going to be nervous, and that nerves are not always a bad thing. You'd have to be pretty strange, I think, not to feel a little bit of a flutter of nerves in an unfamiliar environment. But in terms of preparation, I always and without fail have what I've already referred to, which is we call them a pre-inquest meeting or a PIM, with those who were representing at inquests. So during those meetings, we go through the entire coronial process with the witness. It's a kind of lengthier version of what I'm doing now in this podcast, but we go through the whole process so that there's no stone left unturned. They understand exactly what's going to happen on the day, explain how it will work on the day, even down to where they sit, etc., and provide practical hints and tips to them for giving evidence. I will then go through the facts of the case with them, which assists to inform me in terms of the clinical understanding of the case, because I'm not a medic, and what questions I might need to ask if, say, helpful information or information that I know will assist the client doesn't come out in the giving of their evidence. So I'm better prepared too. So it helps me. These meetings help me too. Top tips, I think, for the day: always ensure that they have a good working knowledge of their own statement, the clinical records, and any other documents that they might have enclosed with their statement. It's not a memory test. So witnesses are entitled to bring their statements and any other documents with them and refer to them. And even to tell the coroner, I can't quite remember, can I refer to my statement? That's absolutely fine. I always tell witnesses to make sure they can try and get a good night's sleep before the inquest, because it's a long day. It's a long, long day. And people will have been dreading it for ages. So you think, good night's sleep, if they can possibly get it, will stand them in good stead. Most of all, I think try and relax. Really all that's required of any witness is to give an honest account of their involvement. They can't change their involvement. They can't change what's happened, but they can give an honest account of it. We've talked about families attending and sometimes being aggressive or angry or just grief-stricken. Be reassured that it's the coroner's role to stop any adversarial or finger-pointing questions. And if the coroner doesn't fulfil that role, then it's up to the legal representatives to step in to assist and to remind the coroner that actually this is not an adversarial process and these questions shouldn't be permitted. Important to remember that coroners do give quite a bit of leeway to families at inquest because they're the grieving family, particularly if they're unrepresented legally. But that shouldn't mean that families have carte blanche to ask what they like when they like. The coroner's role is to keep matters within the scope of the inquest and to assist potentially with the questions being asked if the coroner feels that they're being asked in a controversial way, albeit within the scope of the inquest. It's also not just about the questions being asked themselves, but also about how they're being asked, purely because, go right back to the beginning, it's just not an adversarial process. Those are my sort of key tips for preparing for an inquest for anybody who's never been before, and it doesn't change no matter the facts of the case.
Yeah, thank you. And we mentioned earlier, you alluded to PFD, Prevention of Future Death reports, and organisational learning reports, because of course another feature of the inquest, as well as the factual evidence of the care that was provided, is to look at the role of the entity in the learning and investigation of the incident that's being carried out by that organisation. Can you explain what a Prevention of Future Deaths report is and why it's such a key part of the coroner's role, particularly in terms of driving learning and improvements in clinical care?
Yes, of course. So it is really important. But to go back to the very beginning, a Prevention of Future Deaths report does exactly what it says on the tin. So again, it comes from the Coroners and Justice Act, paragraph 7, schedule 5. Coroners have a duty to make these reports to a person, organisation, local authority or government department or agency where the coroner believes that action should be taken to prevent future deaths. They're also known as Regulation 28 reports. So for anybody who attends an inquest and hears that, it's the same thing as a Prevention of Future Death report. And they're issued if the coroner feels that organisational or systemic failings have contributed to the death of a service user or a patient. They will then potentially issue a Prevention of Future Death report if they're concerned that the same failings will happen again and could lead to further deaths in the future.
So they're quite specific then.
Quite specific, yeah. The issue with them, I suppose, for most organisations is that they are public documents and can therefore cause quite significant reputational damage for anybody who's reviewing them for the organisation. And so we try to, as legal representatives, we try to avoid them for the client's sake, if at all possible. But on a more practical level, they also require the organisation to respond to the coroner in writing and to show the coroner what steps have been taken in relation to the report that has been sent to the organisation, what the organisation has done in response. So it's generally about what changes have been made by the organisation, and they only have 56 days to do it, to respond. So administratively, in the busy environment in which we all work these days, it can be really difficult to achieve on top of what is already a busy workload. So long story short, we try to ensure that our clients don't get prevention of future death reports made against them, and there are ways to advise to try and avoid that.
Yeah, because to clarify on that, it's the position that the coroner finds at the date of the inquest, isn't it, rather than the position at the date of the death. So there is a window of opportunity for a healthcare entity to make changes, or at least to identify actions between the date of the death and the date of the inquest, so that they can say to the coroner and demonstrate that they have learned lessons and that they have made the necessary changes, or they are in the process of being made.
Yep, exactly that. So they don't have to be fully invoked, the new processes and policies, procedures, etc., whatever it may be, but certainly in process. And I think this goes back to the point that organisations, anybody who's facing an inquest and needs some help, the sooner they get that legal help, as soon as they know about the inquest, the sooner that they get that legal help, the better, because then we can assist, or whoever can assist, in giving advice about what that organisation needs to do to try and prevent a prevention of future deaths report being made. And the longer we have to do it, the more time the organisation has to do it, which takes the pressure off. But it also shows that the organisation has taken the matter seriously and hasn't just decided the day before the inquest, oh, we better have a meeting. You know, they've thought about it long and hard over the months preceding the inquest. So just another top tip, really. If you are facing an inquest, don't put it on the back burner. You know, get the help that you need as soon as you can, because it will give you the time that you might need to try and prevent these reports from being made.
Yeah, and I guess as a sort of adjunct to that, with my insurance hat on, it's notify your insurers and engage your insurers and any assistance that your insurers are able to provide at an early stage.
Absolutely, because although mistakes may have been made, or organisational failings may have been the case at the time of the death, it's about learning. The organisation may not have known about certain things being a danger, and the organisation may then review it, reflect on it, put all heads together, etc., and then realise, actually, I'm not sure this policy is safe, let's change it. So it's about the learning, and then you would be able to say at inquest, well, we've really taken this seriously, we've reflected, we've learned, we've changed policies, we've done X, Y, Z. So, coroner, you can be assured and reassured that this will never happen again, so you don't need to issue a prevention of future deaths report.
So it's very important to have an effective investigation into the incident. And I know that for a number of NHS providers, at least, or providers who are working with treating NHS patients, that has changed significantly recently with the PSURF report coming out in place of the serious incident investigation report, root cause analysis, that we used to see. How does that, because I'm slightly sort of grappling here, but my understanding is that PSURF is much more of a process than a single report. How would you recommend that providers work together with coroners to make sure that their investigations are going to be producing the information that the coroner is going to expect to see at a later inquest?
I think it's difficult, because I always think inquests are quite strange in that the coroner absolutely runs the show. So the coroner, you might get a coroner that is really engaging, but you'll never be able to speak to the coroner themselves because they have their offices. So you're always one person removed from a coroner in any event. But I think it's about being open, honest, letting the coroner know, look, you know, these are the issues that we've identified. The coroner is always going to encourage, for example, GP practices to liaise with hospitals in relation to learning, systemic changes, etc., etc. There's never going to be a time when a coroner isn't going to encourage the likes of that example, and there are many, many others. But the other thing is, I think as long as, and it's difficult because a PFD is about organisational learning it's an organisation. It can't necessarily, it very rarely could be given against an individual. It's more about a report being made against an organisation. But an organisation can't talk. So the organisation will have somebody from the organisation giving evidence at the inquest. And I think that overall, if an organisation, any organisation, whether it's working with others or not, can show reflection, taking it seriously, changes made, or even reviewed, reflected, taken it seriously, but no changes deemed to be necessary in some circumstances, I think that's okay. So I don't think we need to get too bogged down, because actually, provided we can show the learning, I think that we can avoid prevention of future death reports. So it's actually more about thinking outside the box and getting potentially the advice that you might need in order to know what sorts of things the coroner's looking for, not necessarily how things interact between organisations and what they can do to work together. That's wonderful, that's great, but not every organisation is going to be able to do that. So it's just about the learning.
Yeah, sure. I mean, these are all sort of pretty familiar themes that we see throughout health and care: candour, learning. And I guess one of the main drivers for the main driver for a PFD report is around, in a clinical context, patient safety, and helping to build a culture where there's been lessons learned from a death. Looking at the bigger picture, how can healthcare providers, carers, and I guess insurers work together, in your experience, to help to build a culture where learning from deaths and learning from the inquest process itself becomes a real driver for safer care, rather than just a reactive exercise after things have gone wrong?
I think this is one of those questions that absolutely is top of the agenda in so many different forums these days. We hear it talked about so much because of Hillsborough, etc., and Hillsborough law coming in, although when that's going to be, I'm not 100% sure. But I think it's more holistic than the law and legislation. I think every one of us in a management role has to ensure that the message to be widely disseminated is that mistakes are sometimes made, and that taking ownership when it happens is so much better for both the individual and the organisation in terms of genuine learning from it, as opposed to, oh, let's react now that this person's died. So if you have a culture which is encouraging people to come forward and take ownership, that's obviously going to help. But there is often a culture, I think, we've seen it with the Let Be inquiry recently, where people are potentially afraid to own up, afraid to take ownership, not just of mistakes, but actively covering things up in fear of consequences. I'm talking about not just Lucy Letby in terms of covering up murders, but chief executives. We're hearing evidence being given about people being afraid to take ownership. And that's important that people do, because I don't think people realise the consequences of not doing so, the potential consequences. Perhaps it's human nature, perhaps it's instinct to protect oneself, but it's not what's expected of healthcare professionals these days. And with Hillsborough, I think that expands across the board to not just healthcare professionals, but literally everybody. We talked about public inquiries briefly just now, but they all talk about this duty of candour. They all talk about how culture needs to change within organisations, because candour is the only way in which learning can take place to prevent deaths of service users, patients, or other negative consequences. And I think reflection and encouragement is a real big part of the exercise for every organisation to take on board and to disseminate down from the top to the bottom. Every aspect of my work involves advice to clients surrounding the need to be reflective, for example, not just inquest, GMC proceedings, NMC proceedings, any regulatory proceedings are all involve this idea that practitioners need to be reflective and to consider what's happened and to set out what the practitioners learnt from the situation. I think the message to get across is that when this happens, the mistakes are then less likely to be repeated. And by definition, safer care then ensues. As we've said, we've got Hillsborough law about to be implemented. And I think it's something that we all now need to embrace for our own self-reflection, to make each of us, including lawyers actually, better practitioners, to show openness, transparency when needed, and to try to prevent consequences such as the likes that we've been discussing today, which can include PFD reports, and also on an individual basis, a requirement for that person potentially to self-refer to their own regulatory body if they're criticised by a coroner. So it's a general concept, but I think it starts at the top and it goes all the way down to the bottom. It's just a matter of taking the taboo out of mistakes. It's okay to accept, take ownership, and to have an open policy and even an open door policy. So I think it starts with that, and then we can build a safer environment.
Yeah, it's a fantastic answer. Thank you. Just to wrap it up, we talked a little bit earlier about, I think you mentioned how the inquest can sometimes be used as a bit of a testing ground by prospective litigants who may have one eye on a future legal claim. And I just wanted to ask you about the process really of sort of joining up inquests with the potential of a claim and the strategic considerations and the proactive steps that healthcare providers and their insurers can take during an inquest process, not necessarily at the hearing itself, but during the process to best protect themselves against a future legal claim for compensation.
Yeah, so it's a tricky question because by the time someone gets to an inquest to give evidence, the care has taken place, the person's sadly passed away, but the care has taken place, whether that be good care or bad care. So whilst the coroner can get expert evidence, although that happens relatively rarely, and again, a whole other topic as to whether we would advise anybody to get expert evidence because there could be consequences in terms of disclosure issues if there is then a subsequent civil claim. But the expert might have given their evidence, but evidence of what has already happened simply can't be changed. And it certainly can't be manufactured. So if the evidence given at an inquest fulfills the criteria for a claim to be brought, then there's not very much that I feel can be done to prevent it.
If the evidence suggests that a claim is likely to be brought and there are issues with the care provided and any claim is likely to be successful, are there any benefits in your view to being proactive with regards to the claim by, I don't know, making an early admission of liability before an inquest? Are there any benefits of doing that or is that not really a consideration?
Sometimes. I think it depends on the facts of the case, but again, a whole other topic. But you can make pre-inquest admissions, but you've got to assess on a case-by-case basis whether that's actually going to benefit your client or not. In some cases it would, and in some cases it wouldn't. I have to say that that's not my area at all, so I wouldn't know. But I do know from cases that I've had very recently that there's been discussions about with our claims team, in fact, at DWF, in terms of whether we should make pre-inquest admissions. And it's been felt, even though there was significant doubt about the actions taken by our particular client in that case, in terms of a potential claim being brought, that pre-inquest admissions just wouldn't be appropriate because it just wouldn't have benefited the client.
Thank you. Well, I think we'll draw it to a close there. It's been a really fascinating discussion. I think that it's very interesting how so many of the same themes around candor and learning and patient safety really pervade through inquests as they do with so much of the medico-legal space. And I'm very grateful to you for taking the time to come and talk to us today about that, Charlotte, and for being such a great guest on Altea Talks.
Oh, thank you. No, it's absolutely my pleasure. It is interesting. And I think that we're going to see a lot more about duty of candour in every single aspect, particularly of healthcare, because that's where it all started, but going forwards in all aspects of our lives, I think. But it's been absolutely my pleasure today. Thank you so much for having me.
It's been a pleasure. Thank you. Thank you for tuning in. I hope you enjoyed today's episode of Altea Talks. If you did, please don't forget to subscribe or leave a like or a review on whatever platform you're listening on, as this helps spread the word. If you have any questions or comments or topics you'd like us to explore in future episodes, please do contact us, as we'd love to hear from you. You can find us on LinkedIn or visit our website at www.altainsurance.com. Stay tuned for more episodes, and until next time, take care of yourselves. The information contained in this podcast is not intended to represent a complete analysis of the topics presented. It is provided for information purposes only for practitioners in the UK. It's not intended as legal advice, and no responsibility can be accepted by Altea or DWF Group for any reliance placed upon it. Independent legal advice should always be obtained before applying any information to particular circumstances.